Good afternoon, and welcome to the New Civil Liberties Alliance. My name is Richard Samp. I am Senior Litigation Counsel here at NCLA. Today's Luncheon Law program is entitled Garland versus Cargill, Will SCOTUS Stop Agencies from Legislating? And we have the honor today of having perhaps the two most knowledgeable people about the case to discuss the case in general, and also the fact that the case was argued yesterday in the U.S. Supreme Court. They were both in attendance at that oral argument, and they're here to tell you how they thought that oral argument went. First, we have an honor to have our client in this case, Michael Cargill. Michael is the owner of Central Texas Gun Works, which is located in Austin, Texas. During his time in the U.S. Army and in the private sector, he has trained more than 50,000 people on proper and safe use of handguns. Jonathan Mitchell, who argued the case yesterday on behalf of Mr. Cargill in the Supreme Court, is an accomplished constitutional appellate litigator who clerked for Justice Scalia on the U.S. Supreme Court before going on to become Solicitor General for the state of Texas. He is now in private practice in Austin, Texas, and we are honored to have him be our advocate before the U.S. Supreme Court. So, Michael, I would first like to ask you to tell us a little about the background of this case. As I think most of our audience knows, in 2018, the Bureau of Alcohol, Tobacco, Firearms, and Explosives ruled that bump stocks are illegal and can subject one to 10 years in federal prison if one is found in possession of them. So, Michael, can you tell us a little bit about how that decision affected you and perhaps your decision to become involved in this litigation?
Yes, sir, absolutely. And thank you for having me. It was 2018 when this happened. And the thing that really disturbed me is the fact that the ATF, a government agency, decided they were going to ban bump stocks. And bump stocks really wasn't something that I was actually on my radar. It was just a part or piece, no big deal about it. It wasn't like a very popular item that was being sold in gun stores. But for some reason, I guess because of the shooting that happened in Las Vegas, which was a very heinous crime, and my thoughts and prayers go out to the victims that are still experiencing that today. But because of that, the government decided they were going to ban them, not going through Congress, not going, through, any other means. They decided they were just going to do it by administrative rule through the Alcohol, Tobacco, and Firearms. And so that just threw me for a loop, and I was just really upset about it. And so I didn't want to give up my bump stocks at all. What I wanted to do was keep them and not surrender them, and definitely not destroy them. I don't like destroying any parts or guns or anything like that. So I started looking for someone that actually could represent me. And I figured that because this is such a heated topic, it would need to be someone that actually was going to be able to push this case to the United States Supreme Court. So I was looking for someone, and luckily I received a phone call from NCLA, and it was like a match made in heaven. They were looking for a client, and I was looking for someone to represent me to push a case toward the United States Supreme Court to hopefully, with a little luck, be able to get this overturned.
Well, thank you, Michael. And Jonathan, perhaps you can tell us a little bit about what was the basis for the ATF making the decision to ban bump stocks, which, by the way, for many years before then, ATF had said were perfectly legal. And how did the case get to where we are today? We're not hearing you, Jonathan. I think you're on mute.
You're right. I was muted. I'm sorry. Yeah. So as Rich points out, ATF had said for many years that bump stocks were legal and that they did not qualify as machine guns under the federal statute that bans possession and use of machine guns. And they changed their position in 2018 in response to the Las Vegas massacre, and also in response to a directive from then President Trump. So the way they've tried to justify this legally is to take the statutory definition of machine gun, which defines machine gun as a weapon that fires more than one shot automatically by a single function of the trigger, and essentially say that single function of the trigger should be read to mean single pull of the trigger. So that with a bump stock equipped rifle, if the shooter pulls the trigger once and then causes the trigger to bump repeatedly into his finger after pulling it the first time, that somehow makes the weapon into a machine gun. So that's their statutory argument. There are problems with it. The most obvious one is the text of the statute doesn't say pull the trigger, it says function of the trigger. But that was the attempted argument made by ATF in 2018, and that's the argument we've been attacking since we filed suit on behalf of Mr. Cargill.
Now, the Supreme Court eventually agreed to hear this case after Michael won his case in front of the all 16 members of the U.S. Court of Appeals in New Orleans. Can you explain why the Supreme Court might have agreed to hear the case and to reconsider the Fifth Circuit's decision?
So the Fifth Circuit's decision created a division of authority among the courts of appeals. The D.C. Circuit upheld the legality of the bump stock rule. The Sixth Circuit upheld it by an evenly divided court, and the 10th Circuit upheld it, and efforts to have that ruling reversed en banc failed. So there was not only a division among the courts of appeals, but a very strong division among individual judges who had heard the case. The Sixth Circuit, it was evenly split. On the 10th Circuit, it wasn't quite evenly split, but it was close. On the Fifth Circuit, it was more lopsided. It was 13-3 in our favor when they took the issue en banc. But the Supreme Court will almost always step in when you see courts of appeals issuing diverging conclusions, and especially in a case where so many individual judges came out on different sides of the issue.
And let me just add to that. First of all, the Sixth Circuit, which at first was evenly divided, later a three-judge panel heard the case, and they unanimously ruled the same way that the Fifth Circuit did in support of our position. Plus, there is a military court of appeals that ruled in favor of our view of the statute, and the government didn't even bother to try to appeal from that decision. So I think it's fair to say that while the courts were split, a significant majority of the lower courts ruled in our favor on that issue. So anyway, the Supreme Court agreed to hear the case, and it was argued in front of all 9 Supreme Court justices yesterday. And let me start with Michael. You were there in the courtroom, although I thought it was a little disappointing that the powers that be there didn't choose to give you a seat in the front. So it may not have been the easiest view to hear the court, but can you just give me quickly your impressions of how you thought the argument went?
First, I want to talk about just the experience of being in the United States Supreme Court, because just being in that room, looking, just feeling the energy from just the history of being in that sacred hall, sacred ground, it was just amazing to me. I was just overwhelmed by just those emotions. I thought that as far as the case, I thought the attorney did a wonderful job. He did an outstanding job of, defending my position, and also defending not in this case, it's just not about firearms to me. It's about something a little more. And I thought he did a wonderful job in standing up for, our position in that. I feel that I got the impression, judging by some of the questions that were asked, is that we're going to, possibly get maybe a 5-4, decision on that. And that's just a guess on my part. And I'm hopeful, praying that comes to true.
All right. Now, of course, the final vote in the Supreme Court is going to be a majority vote. So it's really up to the views of each of the individual justices. So, Jonathan, why don't you try to give me a brief synopsis of what you thought were some of the concerns that were raised by the justices generally, and then maybe later we can get into kind of justice by justice where they stand.
I think they raised some concerns with both lawyers. I'll start with the concerns they expressed to the government's lawyer, because he argued first. Now, the problem and the weakness with his argument is it just doesn't accord with the statutory text. And this is a court that has a very strong textualist bent. So he did get questions from some of the conservative Republican appointed justices about how he could reconcile his interpretation, or ATF's interpretation, of the statutory definition of machine gun with what the language actually says. We got more questions from liberal justices who were concerned about the policy consequences of our position. And again, I think that's to be expected from those type of jurists, because they treat statutory interpretation somewhat differently from the way that we interpret statutes. But that really, I think, in a nutshell, summarizes the divide on the court. I think it was a split between the court's textualists and the court's pragmatists. So I got a lot of questions about the consequences of our position. I got a lot of questions about how the implications of our argument might extend to other types of weaponry. And the government's lawyer got a lot of questions about the statute and the actual language that appears in the statute.
And let me just briefly explain. Textualism is a form of statutory and constitutional interpretation that posits that we ought to be looking primarily at the words used in the statute in terms of trying to discern its meaning. And we really ought not to be trying to discern some unexpressed purpose of the statute as a way of trying to divine the meaning. That really ought to look at the words. From time to time, various of the justices have suggested that, well, we're all textualists now, and that that while perhaps looking at the purpose of the statute was important during the Warren Court era of the 1960s and early 70s, that now justices are much more likely to look at the text. But I think that the division between textualists and non-textualists is still there, and perhaps it was best epitomized by a comment from Justice Kagan, who really sometimes claims to be a textualist, but what she said yesterday was that while she is sometimes a textualist, she doesn't allow the text of a statute to overcome common sense. And I think what she really meant by that is if she thinks that the purpose of the statute is contrary to the text of the statute, well, then that means that common sense means you ought to go with the purpose rather than the text. And perhaps what some people see as the purpose of the 1934 definition of machine guns was to try to stop the mob from using Tommy guns, and the Tommy guns were dangerous because they shot lots of bullets very quickly. So therefore, the purpose of the statute should be to ban any weapon that results in rapid shooting, even if the text of the statute would suggest that perhaps that bump stocks are not covered by the definition of machine gun. In any event, why don't we start with Michael, and I'd like just to ask you, what do you think was the hardest question that was asked yesterday to NCLA's counsel, and what would struck you as if we are perhaps not going to win the case or have certain of the liberals vote against us? What were the concerns that made you think that might be true?
I wouldn't say the hardest question, but the question that I thought was hard for the counsel to explain to the justice, and that was Justice Jackson, was just the function of the trigger and how does the trigger function. The fact that one action of the trigger, more than one round goes out, that's going to be a machine gun, or one action of the trigger, only one round goes out, that's a semi-automatic. And the fact that there's a sear that's involved in the trigger and how the trigger works, if that sear is there, that's going to turn into a machine gun. So it was just, to me, it was difficult for counsel to explain that to the justice. I thought that was one of the hardest things, and I almost came out of my seat, wanting to say something. No.
And Jonathan, why don't you tell us what you think was the hardest question that you had to answer during yesterday's argument?
I think the most frustrating aspect of yesterday's argument was the fact that I was getting questions, especially from Justice Jackson, that were just premised on factual falsehoods. I mean, she would ask loaded questions that revealed a misunderstanding of how firearms work and how bump stocks work. And I had to spend a lot of my time correcting the problems in her question rather than actually addressing her concern. So that was a difficult tactic just to navigate, because the concern when you get a loaded question from anybody is if you answer it, you're implicitly conceding the error in the factual premise of the question. So you need to immediately begin by pushing back on the mistaken factual understanding that the justice has. And then after you do that, if you have time, you then try to address that justice's substantive concerns. But often when that happens, some other justice has cut in with another question. So that was one of the challenges. Of course, I knew I wasn't going to get Justice Jackson's vote anyway. So you really are in those situations when you have a justice who you can't persuade. You need to think about whether the questions or concerns they're raising might influence another member of the court. And that's really how you have to address these types of questions from a hostile judge that you have no chance of getting.
Yeah,
and that was true. Yeah, go ahead. Yeah, that was true of a lot of questions I got from Justice Kagan and Justice Sotomayor. They really weren't justices or members of the bench that were persuadable. So when you answer their questions, you need to be answering them really for the other justices who are persuaded. And think about really not so much allaying their concerns, because you're not going to be able to allay their concerns, but think about whether the concerns they're expressing might be shared by another member of the bench who is in play, and then try to answer that question in a way that could allay that other justice's concern. So that's really how you had to try to approach this. It's not the most satisfying way to approach oral argument, because ideally you would like to directly engage the justices when they're asking the questions and express their concerns. But this wasn't the type of argument where the questions were being offered in that spirit.
Frankly, my feeling was that on the one hand, the questions from Justice Jackson were somewhat frustrating. On the other hand, they didn't bother me in the slightest, because in general, my feeling was she misunderstood the definition of the word function. She was equating function with purpose rather than function meaning operation. And clearly, at least in the context of this statute, function can't mean purpose, because it refers in the statute to a single function of the trigger, and it would make no sense to talk about multiple purposes of the trigger. It could only mean multiple actions of the trigger, as what function could mean. But I can see why questions asked by both Justice Sotomayor and Justice Kagan might have influence on the other justices. In particular, I thought that Justice Kagan asked a very pointed question to counsel for the government when she asked for a comparison of how quickly can an automatic weapon shoot, and how quickly can a semi-automatic equipped with a bump stock shoot, and how quickly can a semi-automatic without a bump stock shoot. And I think her question revealed that at least there's some argument that basically that the rate of fire of a bump stock is equivalent or relatively close to the rate of fire of an automatic weapon. And given those line of questions, Jonathan, I'm wondering, what did you see as your best way of responding to that concern?
That's just not what the statute says. The statute does not define machine guns according to rate of fire. And Congress could have enacted a statute to define machine gun that way, and they didn't. So Justice Kagan and the lawyer for the government and Justice Jackson can talk all they want about how bump stocks accelerate the rate of fire of a semi-automatic rifle. We all admit that. Yes, bump stocks accelerate the rate of fire. That has zero relevance whether it's a machine gun. What matters with the statute is whether the weapon fires more than one shot automatically by a single function of the trigger. And the answer is no, because the trigger must reset after every single shot, no matter how quickly the shots are occurring. And the trigger must be bumped and reactivated again before any subsequent shot can be fired. So that means there is one shot per function of the trigger. One function, one shot. And I didn't hear an answer to that from the government or from any of the liberal justices on how they get around that problem.
Michael, I have a question for you about what I thought was kind of a difficult question. And I'm not sure exactly which justices came from, but I think it was from one of the conservative justices, where Justice Sotomayor had questioned whether or not the purpose of bump stocks really was to help people who are perhaps somewhat arthritic or have difficulty with fingers, and that allows them to operate a semi-automatic weapon more easily than they otherwise could. And it may have been Justice Kavanaugh who asked the question, do you really think that a rational legislature would decide that, okay, we are going to ban automatic weapons because they shoot quickly, but we are going to permit bump stocks because we want to help people with limited finger dexterity shoot a weapon as though it were an automatic weapon and almost as fast as an automatic weapon.
Right.
And I'm wondering, when you hear a question like that, what is the rationale for having this product on the market? And does it make any difference? Because at the end of the day, Congress ought to pass a law rather than if it wants to ban them, rather than allowing courts to second guess why a Congress might have did what it did.
Right. I don't think it really matters whether it's practical or not. It's a part that's out there. People do use it because of that reason. People use it because of they may have had some type of injury. For example, I have a metal plate and 7 screws on my wrist here. So I tried to use it with my left hand to be able to shoot a little easier. So that's a reason that some people use it. Some people just use it just to have fun. And just to be able to, like I guess the creator said, a poor man's version of, a machine gun. but it's not really a machine gun.
Okay. And I'd like to go back to you for a second, Jonathan, just to say, what do you think were the hardest questions for the government? What do you think that, and frankly, I have to say that Brian Fletcher, who argued for the government, is a very capable advocate at the Solicitor General's office, and I thought did a very good job of defending what I think is a difficult position. But what do you think was the hardest question he had to face, or at least the question that he had the hardest time answering?
I agree with you that Brian Fletcher did a really good job considering how difficult his argument was on the text. And I think as I was listening to his presentation, I think the challenge he faced, and I don't think he was able to address this because I don't think it can be addressed, is how they can square their argument with the actual text of the statute, single function of the trigger and automatically. And he did have arguments for why bump stock equipped rifles operate in a manner that is similar to automatic rifles. And that's a perfectly respectable argument for a judge who is more pragmatic in their orientation, more consequentialist, and less formalist. I don't think those arguments are going to persuade textualists that have, or I should say justices that have more of a textualist bent. And, I think if I were representing the government, I would have taken the exact same tack that he did. This is not a criticism of Brian Fletcher's performance, but given the hand that he was dealt, he needed to do more, I think, to allay the concerns that a textualist justice would have that this is simply not what the statute says. And it seemed to me in his argument, he was running away from the statutory text when conservatives tried to steer him back toward the statutory text, he just didn't have a really good answer for how you can say that multiple shots are firing from a single function of the trigger, as opposed to a single pull of the trigger. If you want to accept ATF's rewrite of the statute, well, then he has a good argument. The problem is, I don't think the conservative justices are going to accept ATF's rewrite of the statute.
Now, Michael, I know that one of the principal arguments that Mr. Fletcher raised was, why are we trying to differentiate between a bump stock equipped semi-automatic weapon and a fully automatic weapon? Because they really operate pretty much the same way. With one of them, you hold and pull a trigger and keep holding it, and with a bump stock, you push out with your non trigger hand and hold it constantly forward. And isn't that pretty much the same as somebody who shoots an automatic weapon with kind of doing one continuous motion of holding a trigger? Now, of course, I've seen people operating automatic weapons, and they don't even have to hold it with two hands. They're just kind of holding their trigger finger, and the gun keeps firing until it runs out of bullets. What's your sense? Do you really think that these two weapons are equivalent? Can you operate a bump stock as easily as you can operate an automatic weapon, or are they really different types of weapons altogether?
No, I think they're different types of designs altogether. When you talk about a machine gun, you're talking about there's a sear inside. You're talking holding the trigger, just like you said, and all the rounds will go out. That's in the magazine. Versus,
and just to make it clear, you hold the trigger once, it doesn't have to keep moving back.
That is correct. It's not going to reset.
And how is that different on a bump stock?
So on the bump stock, the trigger is resetting. So you're actually pressing the trigger each time, and it's resetting inside, the trigger. It's not just one function. So it's doing you're pulling the trigger, it's resetting on a semi-automatic, and you release the trigger, you press the trigger, another round goes out, release the trigger, resets, press the trigger, another round goes out, release the trigger, it resets. On a machine gun and automatic, I'm going to hold that trigger and it shoots multiple rounds.
All right. And if you have a machine gun that's up on a tripod, I understand you could operate it with one hand.
Correct.
Can you operate a bump stock equipped semi-automatic with just one hand?
Possibly. There could be a way, but it does need that forward pressure, but possibly it can. With the same mindset, then what about a shotgun? So a shotgun, I can do the same thing. I can pump the shotgun, pull the trigger, pump the shotgun, pull the trigger. So to me, that's saying the same thing. You're kind of describing the bump stock in a sort of kind of way.
Well, and you say maybe you could do it with one hand, but don't you have to push forward with your one hand and then pull back with your other hand in order to make it operate?
You're going to need the two hands. That's correct.
Okay. So to me, that's kind of a major difference between the two of them.
Absolutely.
All right. Jonathan, why don't we discuss some of the individual justices on the court and where you think they're leaning? I think we can, based on what we've discussed so far, it is fairly clear that the three liberals on the court, who are perhaps the least likely to be textualists, are likely to vote against us. Let's discuss some of the individual justices. What do you think about Justice Gorsuch? Where does he stand on this?
Based on his questioning, he seems very favorably inclined toward our position. It's always dangerous to try to predict these things from oral argument, because justices will often ask tough questions of both sides. And that doesn't necessarily mean that they're going to vote against the lawyer that they're pressing. But he certainly had challenging questions for the government. He didn't ask us anything that made me think he had concerns about the arguments that we were making. So he seems to be, I think, someone who has a lot of concerns. And he's also, just as a general matter, very skeptical of agency power, I think more so than any of the.
And didn't he already write an opinion several years ago about bump stocks and the whole idea that perhaps this statute doesn't clearly set out that this is really a crime to possess a bump stock?
Yeah, he expressed some concerns in a case that came up on petition for certiorari. The Supreme Court denied cert. He wrote a separate opinion concurring in the denial of cert, but at the same time, he expressed concerns with what happened in the lower courts below. It was primarily on the way they treated the alleged ambiguities in the statute. And he thought that deference to the agency should not apply in that particular case. So he's been aware of this issue for quite a while. He's waited on it before, and he seems to care enough about it to have written separately back when they denied cert in the Gwetty's case, the Canada DC Circuit.
Also, Michael, Jonathan's absolutely right that it's always dangerous to try to predict how people are going to vote in a case. On the other hand, you were there in court, you heard the questions that they were asking, and you can try to judge their body language a little bit. If you had to guess, besides Justice Gorsuch, who would you say was perhaps most favorable to our position among the 9 justices?
I think Justice Thomas was favorable to our position. I think the majority of the conservative justices that are on that panel are going to be favorable to our position. So I have to see what happens, and I hate to talk about it.
And I know that Jonathan is going to be very reluctant, given that he was the one who made the very able argument on our side to make predictions. But of course, for the remainder of this program, Jonathan, I'm going to be prodding you as much as I can to say what you're willing to say, even if you're reluctant to do so. I guess, what did you make of the questions of Justice Alito? What were some of the things that he asked to the 2 sides that might give an indication of how he is leaning?
He seemed to be the most knowledgeable about how firearms work, which I thought was helpful, given that some of the questions we got from other members of the court did not reflect a proper understanding of how the actual mechanics of the bump stock device function. So, again, I didn't hear questions from Justice Alito that would suggest that he had concerns with our argument, which that's often a good sign. But again, you can never know for sure. We got no questions, hardly any questions from Chief Justice Roberts. He really tried to hold his cards close to his chest throughout that entire argument. And I wouldn't characterize Justice Alito that way. He had tough questions for the government, and he had some interesting questions for our side as well. But there are certain questions I would have expected to hear from the conservative justices if they had concerns with our textual argument. For example, I never got a question from any of the conservatives about what to do in the event they considered the statute ambiguous. They didn't ask about whether they should apply the rule of lenity. They did not ask about whether or to what extent they should apply canons of construction. So I was more encouraged, I think, by what I didn't hear from the bench on the conservative side than by what I did hear. Because I would think that if there were concerns about our textual argument, we would have at least had one or more questions along those lines. So that's my attempt to read the tea leaves. I do think good judges will try to ask tough questions of both lawyers at oral argument, regardless of where they're leaning on the substance. So I don't want to infer too much just because somebody asked a tough question of the government or because somebody asked a tough question to me. But I think sometimes you can discern a lot from what's not being asked. And sometimes that's more helpful in predicting how the court might go than by focusing on what actually was being asked.
One of the things that I thought was perhaps the toughest series of questions for the government had to do with the potential effect of retroactively interpreting a statute. This statute was written in 1934. For many years, ATF said that bump stocks were not machine guns, and as a result, 500,000 were sold prior to 2018. One of the purchasers, of course, was Michael. He bought 2. But the result of ATF's decision to say that, we made a mistake in our prior interpretation, and in fact, it has always been the case that bump stocks were illegal. The result of that was to essentially say you were a felon, and I'm wondering how that affects you, Michael.
what scared me, scared the daylights out of me for starters. The whole thing about this entire process, though, because I was just thinking about this, that's frustrating is we talked about this yesterday, the relief part of it. And, I wanted to get to that a little bit before we run out of time. The fact that I've won this case in the Fifth Circuit for Texas, Louisiana, Mississippi. This case is now sitting in front of the Supreme Court. And if, let's say, by the grace of God, we actually win in the Supreme Court, then I still don't necessarily get the bump stocks back yet. And that's the frustrating part of the entire process.
Yeah, and let me just tell the audience that basically the district judge, of course, ruled against us initially. So he probably was not very happy when the Fifth Circuit slapped him down and said by a vote of 13-3 that he was wrong. So what happened was we went back to him and said, would you enter judgment for us? And he issued a piece of paper that basically said, judgment, but he didn't provide any relief at all. So we are arguing in front of the Fifth Circuit that in fact he was required to do more than that. So that's one of the issues that will have to be decided if the case goes back on remand to the lower courts. But Jonathan, I want to return to the issue of retroactive illegality. What did you make of those questions, which were actually primarily focused to Mr. Fletcher, and how did you think he responded to those questions?
I thought he handled them as well as he could, but this is a problem for his position because, as you point out, if the Supreme Court were to endorse the ATF role as the proper interpretation of the statute, it will retroactively make all sorts of people into felons, even though they relied on ATF's repeated 15 different classification years prior to 2018 saying the bump stocks were legal. I think it also puts the liberal justices in a tough spot because, imagine an agency were doing this, but just changed the subject matter from guns to, say, abortion, and an agency rule retroactively made certain categories of abortion providers into criminals. I can't imagine liberal justices would allow something like that to go unnoticed. And what would they do if this were being done by an agency with regard to some policy or some right that they actually care about, as opposed to a right that they don't particularly care about, such as the right to keep and bear arms? So I'm wondering if that's something they're going to play up in the opinion, just to try to see how Kagan, Sotomayor, and Jackson will respond. But if they want to go on record saying that it's just perfectly okay for agencies to change their longstanding position and retroactively make people into criminals, well, let's see what happens when the Trump administration revokes the Biden administration's interpretation of the Federal Comstock Act and retroactively makes all sorts of abortion pill distributors into federal criminals. What are they going to take? Are they going to be equally indifferent to those types of consequences in that type of scenario?
Now, one of Mr. Fletcher's responses to these questions about retroactive criminality was to say, well, I don't think any prosecutor would try to do it retroactively. And in fact, at least up to this point, ATF has said we're not going to try to do that retroactively. But it's one thing to say that you won't go after somebody as a felon if they relied in good faith on the prior ATF position that bump stocks were legal. But what about, say, somebody who holds a license as a gun dealer and now somebody determines that, wait a second, they committed a felony by possessing a bump stock before 2018? Would the government's position prevent somebody coming after somebody's license because, well, you did commit a felony in the past, and therefore we think you're no longer entitled to hold a license? What's your view of the law on that, Jonathan?
I don't think ATF can control the behavior of state licensing authorities. So, yeah, I think Brian Fletcher tried to address that concern by saying that someone who is threatened with loss of licensure by a state official over a violation of this supposed bump stock rule that occurred prior to 2018 could assert an entrapment by estoppel defense. I think he used that phrase several times in his argument. that is a valid defense in a criminal prosecution. I don't know whether that is a defense in a state court procedure to revoke a person's occupational license. So a lot of questions here. And again, I just wonder how this would play out if we changed it from guns to abortion, because right now the Biden administration has interpreted the Federal Comstock Act very narrowly, almost in an atextual fashion. And if the next Republican president tries to say, no, all those previous interpretations of the Comstock Act were wrong, and we're now going to interpret it to mean what it says, and would they then be allowed to prosecute people who acted in reliance on the Biden administration's prior representations of what was permissible under Comstock? I just can't imagine liberal justices in that situation would be so blithely indifferent to the prospect of retroactively converting thousands of people into felons when they relied in good faith on guidance from an executive agency. So we'll see how this plays out in the opinion writing. This did not feature prominently in our brief. We certainly made the point in our brief, but it wasn't a big focus of our brief. It was a big focus of the oral argument. And I was surprised at just how many, not only the number of questions that were asked, but the number of individual justices who expressed concern about that. We heard questions about this from Justice Kavanaugh, from Justice Gorsuch, from Justice Alito. All three of them expressed real concern about it. So again, I think that's a good sign for us that they were so concerned about it. And we'll see how it plays out in the opinion writing. It could be that this actually plays a more significant role in the opinion or in the rationale of the court than maybe we expected that it would.
And you can't control local DAs. What's going to stop a local DA from going back and doing just that?
I that's a very good point. And one of the questions that Justice Kavanaugh asked, kind of related to this, is he asked, what is the mens rea requirement under this statute? And Mr. Fletcher admitted that mens rea, which means what is the state of mind, it doesn't make any difference, according to Mr. Fletcher, that a person charged with violating the law that prohibits possession of machine guns, it doesn't make any difference that that person is aware that this statute has been reinterpreted to say that bump stocks are machine guns. It's the mere knowledge that he possessed a bump stock that would be enough to convict somebody of the crime. And I'm correct, am I not, that there are people since your victory in the Fifth Circuit who are buying bump stocks in Texas. Is that right?
That is correct. There are people that are in Texas, Louisiana, Mississippi are still purchasing them from the creator of bump stocks, going to their website, having them shipped to their homes right now.
And so what would you think if the government were to prevail in this case? According to Mr. Fletcher, it would be perfectly proper for the federal government to then prosecute every single one of them for possession. Do you think that is proper notice of what the law requires?
I don't think it would be just. I don't think it'd be right for them to do that, but I can see that happening. And I've warned people. I've asked them to not purchase them. Wait until this is all said and done. Wait until we hear from the lower court, not just Supreme Court, until you decide that you're going to purchase one of these items.
But of course, there would be no way necessarily of, I mean, you as a gun dealer are well aware of this case and the issue, but it's fair to say that there would be citizens out there who in good faith might think, well, bump stocks are now being sold in Texas, so there's no problem with me buying one.
Correct. People think that they can purchase them now.
I'd like to, Jonathan, just ask you one or two more questions about some of the individual justices. Justice Barrett at one point said, I'm sympathetic, Mr. Fletcher, to the government's position because I can see how some people would think that a bump stock that facilitates rapid fire could be a dangerous weapon. Did you read anything into her statement of sympathy as to how she might vote, or did you view other things that she said as perhaps leaning the other way?
Well, that statement she made was expressing sympathy to the policy goal behind ATF's rule. She wasn't saying that she was expressing sympathy to the government's legal arguments. And the media has taken this quote and used it in all sorts of reports on how argument went yesterday, but they're taking it completely out of context. She says initially, I think this was the first question that was asked of Brian Fletcher, but she expresses sympathy for the desire to ban bump stocks. But then she immediately follows up by expressing concern that the statute Congress wrote doesn't allow ATF to do that. And Justice Gorsuch actually made a similar comment later in the argument, where he said to Brian Fletcher that he could understand why the government would want to ban bump stocks as a policy matter. But none of that has anything to do with the question of law that we're addressing. You can believe that something is good policy and still think that an agency has no power to issue it because the statute doesn't allow them to do it. Those are entirely distinct questions. You might think something is bad policy and also believe the agency has the power to enact that policy that you find normatively undesirable because the statute properly read allows them to do it. They're just two entirely different things. And for a justice to say at oral argument, yes, I can understand as a policy matter why you want to accomplish this, and then simultaneously express concerns about whether this was done legally and whether this was done consistent with congressional instructions, there's no reason to think that justice is inclined to rule against us, because this is ultimately a court of law, not a court of policy. If Justice Barrett said that as a member of Congress, then you might think, gee, she may vote for a law that bans bump stocks. But she's a judge. She's not a legislator. So her policy musings shouldn't really be read as any indication on how she might vote on the legal questions.
Now, I said at the outset that I was going to press as much as possible to get people to make predictions about the case. And I'm going to guess that I'm going to get some resistance to that. I'm going to make a very bold prediction and say that the Supreme Court is going to decide this case before the end of June. That maybe July 1st or 2nd, but they will come up with a decision, and there are an odd number of justices on the case. So therefore, I'm also going to predict that the court is not going to be equally divided, and it's going to decide the case one way or the other. And I'm asking, however, my two panelists to perhaps be a little bit bolder than I am. And why don't we start with you, Michael, and give me your sense of coming away. Did you come away feeling more than 50% confident? Did you come away just thinking, well, you are happy to get your issue presented in the court and you'll leave it to them? What were your feelings as you?
I came away yesterday feeling a little confident that we would do well. And then I went to different news outlets and went to the comment section, and then I felt less confident. So, like I said in the beginning, I'm hoping, for the majority, of course, in our favor. But we'll see what happens. It's in the end, it's in the hands of the court. So, I'm just going to go home and just hopefully and just praying that we actually came through this one.
Now, Jonathan, I should tell you that I had a little bit different experience. I had the luxury of being in front of the Fifth Circuit and arguing this case, and that court has judges that are perhaps more in tune with reading statutes according to their actual language. And so I came away from that argument reasonably confident that we were going to prevail. Having said that, why don't you tell me how you came away from the argument, other than I realize you were frustrated by some of the questions being asked, but you've argued now, I think, 7 times in front of the Supreme Court. How did your reaction yesterday compare with the prior 6?
Oh, in terms of trying to figure out what they might do and with their eventual ruling, is that what you're asking? How did it compare in that regard?
Sure.
Yeah, I mean, most of the cases I've argued previously, it was very easy to tell which judges were against us. And I've never been surprised where I've received questioning from a judge at oral argument that clearly indicates the judge is against us. I've never had one of those judges surprise me by voting for me. So I think I can say with a fair degree of confidence, we're not going to get the votes of Justices Sotomayor, Jackson, or Kagan. With respect to the other justices, it's harder to say. I mean, a justice may seem sympathetic toward your view at oral argument, but I don't think that's ever a guarantee he's going to vote your way. It's usually easier to tell at oral argument who's going to vote against you. And again, I've never been surprised in my previous arguments where a judge who was obviously hostile winds up voting for my position. So I think I can say that with a fair degree of confidence. I don't think that's being presumptuous or disrespectful to the court. I certainly don't like to predict on the record which justices will vote for me, because that does come across as somewhat presumptuous. So I will go out on a limb and say that we're not going to get the votes of Justices Jackson or Kagan or Sotomayor. With respect to the remaining 6, we'll have to see how it plays out. And it's also hard to know what rationale they're going to go on. We got a lot of different questions about different issues in the case. There were, as you were mentioned earlier, a lot of questions about the retroactivity, unfair surprise, due process concerns that seemed to trouble the justices more than I expected that it would. So it's possible that will feature very prominently in whatever opinion gets written on the side of the justices who are going to vote our way. And we didn't get questions about what to do in the event of statutory ambiguity. So given that no one asked about that, that makes me think we're not going to have an opinion from the court that says the statute is ambiguous and that we have to resolve this case by using canons of construction or the rule planning. But again, you never know for sure. I've seen people try to predict outcomes of Supreme Court cases and they wind up making complete fools of themselves. So I'm not going to put myself in that position.
Well, in the few minutes that we have remaining before we go to audience questions, I wanted to kind of take a broader view of the case. There have been complaints over the years, and I'm among the complainers, that the executive branch is very likely to take the attitude that, well, we have the best interests of the country in mind, and we can't seem to get Congress to do our will, and therefore we are going to basically write rules that perhaps we're stretching the meaning of our statutory authority in doing so. And to me, this is a good example of the Trump administration doing that in 2018 when they adopted this Bumpstock rule. There certainly are plenty of examples of the Biden administration doing the very same thing. One that comes to mind is the idea that, well, we think that college graduates aren't making enough money and are too burdened with debt, so we're just going to change the law and wipe out billions of dollars, hundreds of billions of dollars of student debt without getting any authorization from Congress to do so. I guess the only real way to stop that from happening is for the courts to stop it from happening. And I guess I'll start with Michael. What's your take on that? Do you see federal agencies trying to grasp authority that is not theirs in a broader sense, not just with bump stocks, perhaps with other gun-related issues? And did you see any encouragement yesterday from the court that perhaps the court is going to put its foot down and say enough is enough?
I don't think I saw anything going either way, whether the court, because that question didn't come up. The question, to me, I didn't hear it, didn't come up where, government agencies, are they overstepping their authority? So the fact that wasn't asked, that made me think that the justices were probably confident in the way they were going to decide that. So we'll see what happens. I think that the thing that I took away from everything was the fact that we do need a new interpretation of a machine gun. A definition needs to be changed by Congress if they're going to fit bump stocks into that. And also the fact that they didn't bring up the question, of authority, then I'm thinking that maybe they're going to put their foot down and rein in the different agencies. So we'll see what happens.
Jonathan, what is your take on this? Do you see agency overreaching as a significant problem in the federal government, or do you see this case as a one-off?
Oh, it's certainly not a one-off. This is a very significant problem in the federal government. I think the current Supreme Court is very aware of that and is very sensitive to those concerns. We've seen this in their recent cases on administrative law, their efforts to create and reinvigorate this major questions doctrine, talk about possibly reviving the non-delegation doctrine among some justices, which has not happened yet, but it's been hinted at in some of the opinions that we've seen. The recent arguments over the future of Chevron. This is a court where the Republican appointed justices are very concerned about the present day role of administrative agencies, and they are determined to rein them in. So we didn't get a lot of broad thematic questions along those lines at oral argument, but we've seen this consistently from the Roberts Court, especially in the last 5 or 6 years. And we'll have to see how this opinion plays out in terms of the way they write it.